Listen up, because what I'm about to tell you should terrify every American who cares about their rights. The Supreme Court just handed down a unanimous decision, 9-0, folks. That means every single justice agreed. They told lower courts exactly how to handle cases where police use excessive force. Crystal clear instructions. No room for confusion. And guess what happened? A lower court basically said, "Nah, we're good," and did whatever they wanted anyway. This isn't just some boring legal drama. This is about whether the highest court in America actually means anything. And it's about a young man named Aston Barnes who lost his life over unpaid tolls. Picture this: Houston, Texas. Roberto Felix Jr., a police officer, pulls over Aston Barnes. The reason? Toll violations. We're talking about cameras catching someone not paying highway tolls. Maybe it was a rental car. Either way, this was not a murder suspect, not a violent criminal, just unpaid tolls. Officer Felix orders Barnes out of the vehicle. Barnes opens the door. He looks like he's about to step out. Then he makes a terrible decision. He tries to drive away instead. Now, let me be clear. Running from the cops is stupid. It's illegal. It's dangerous. Barnes made a horrible choice in that moment. Nobody's arguing that. But here's where things get insane. As the car starts moving, Officer Felix doesn't step back. He doesn't radio for backup. He doesn't let the guy go and track him down later. No. In a split second, he jumps onto the ledge of the moving car. Think about that. He voluntarily puts himself in danger by jumping onto a moving vehicle. Then, while hanging onto this car as it's driving away, he pulls out his gun and fires 2 shots at Aston Barnes. Both bullets hit. Barnes was fatally wounded. He managed to pull the car over, but he died from his injuries. Over. Unpaid. Tolls. Barnes's mother did what any parent would do. She sued Officer Felix, claiming he violated her son's Fourth Amendment rights. For those who don't know, the Fourth Amendment protects us from unreasonable searches and seizures, and that includes protection from excessive force by police. She argued that shooting someone over a traffic violation, especially when the officer put himself in danger by jumping on the car, was unreasonable. Excessive, a violation of constitutional rights. The case went to district court first. That court sided with the officer using something called the moment of threat rule. This rule, used by the Fifth Circuit Court of Appeals, asks only one question. Was the officer in danger at the exact moment he used deadly force? Under this rule, nothing else matters. What happened before? Irrelevant. What choices the officer made leading up to that moment? Can't consider it. The only thing that counts is that single frozen moment when the trigger was pulled. The court said, officer was on a moving car. Officer felt threatened. Shooting justified. Case closed. The appeals court agreed. Barnes's family lost. But they didn't give up. They took this case all the way to the Supreme Court. And here's where it gets interesting. The Supreme Court didn't just rule in their favor. They ruled unanimously. 9 justices, conservative and liberal, all agreed. The court said the moment of threat rule was wrong. Dead wrong. They explained that when you're judging whether police used excessive force, you can't just look at one frozen moment. You have to look at everything, the totality of circumstances. What does that mean? It means you look at what led up to that moment. What choices did the officer make? Did those choices create the danger? Could a reasonable officer have handled it differently? The Supreme Court specifically said that the totality of circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. In plain English, you can't ignore the fact that the officer jumped onto the moving car. That matters. His choices matter. Context matters. The Supreme Court told the Fifth Circuit to go back and do it again, this time using the correct legal standard. Everyone thought this was over. Justice had been served, right? Wrong. The case went back down to the Fifth Circuit for a new review. And here's where this story becomes absolutely jaw-dropping. The panel of judges didn't hold new oral arguments. They didn't ask for additional legal briefs. They didn't want to hear from either side about how this Supreme Court ruling should apply. They just issued a new ruling. And guess what they said? Even under the totality of circumstances approach, the officer's actions were fine, justified, constitutional. Their reasoning? Anytime someone flees in a vehicle, that creates a deadly threat. Therefore, officers can use lethal force. Period. Read that again. According to this ruling, if you drive away from a traffic stop, police can shoot you. Doesn't matter if it's for murder or for unpaid parking tickets. Doesn't matter if you're unarmed. Doesn't matter if the officer created the danger by jumping on your car. You run, they can shoot. End of story. Barnes's attorneys immediately saw the problem. This new ruling contradicted the Supreme Court's decision. It was the same result with just enough different words to pretend they'd followed orders. Even more bizarre, before the Supreme Court ruling, one of the judges, Judge Higginbotham, had said that if they had to use the totality of circumstances test, there was no way they could rule for the officer. But after being forced to use that test, suddenly he found a way to rule for the officer anyway. The attorneys filed for en banc review. That means they asked the full Fifth Circuit, not just 3 judges, but all of them, to review the case. They argued this ruling creates a dangerous rule, that officers may shoot any fleeing driver, even during minor stops. This contradicts Supreme Court precedent. It contradicts the Fifth Circuit's own previous cases. Running from police in a vehicle does not automatically justify being shot and killed. The Fifth Circuit denied the request. They're not taking another look. On December 21st, they issued their mandate, the official end of the case at their level. So now what? Barnes's family has 90 days from that December 21st date to petition the Supreme Court again. That gives them until around early February 2025, and they're almost certainly going to do it. Think about this timeline. The Supreme Court issued a unanimous decision just 6 months ago. They told the lower court exactly what to do. And now, just months later, the same case could be heading right back to them because the lower court essentially ignored their instructions. This is extraordinary. Courts usually respect Supreme Court rulings. When the highest court in the land tells you how to apply the law, you apply it that way. But the Fifth Circuit seems to have decided they know better than 9 Supreme Court justices. Maybe you're thinking, why should I care about some court case? Here's why. This case determines whether police can shoot you for running from a traffic stop, not for being violent, not for threatening anyone, just for driving away. If the Fifth Circuit's reasoning stands, any traffic stop in those states could turn deadly if you panic and try to leave. Unpaid tolls, broken taillight, expired registration. If you make the terrible decision to flee, police could justify shooting you. And here's the scariest part. This ruling essentially says officers can create dangerous situations and then use the danger they created as justification to use deadly force. Officer Felix jumped onto a moving car. He wasn't dragged. He wasn't trying to stop a murder suspect. He chose to jump on that vehicle, then used the fact that he was on a moving vehicle to justify shooting the driver. Under this logic, an officer could theoretically jump in front of a car, claim they felt threatened when it didn't stop, and shoot the driver. This case represents something deeper than one tragic shooting. It's about whether the Supreme Court's authority means anything. It's about whether lower courts can simply ignore rulings they don't like by using clever legal language. It's about whether totality of circumstances actually means anything, or if courts can manipulate that standard to reach whatever result they want. And most importantly, it's about the value of human life. Aston Barnes made a bad decision, but he didn't deserve to die for unpaid tolls. His mother deserves answers. She deserves justice. The Supreme Court gave her a chance at that justice with their unanimous ruling. The Fifth Circuit appears to have taken it away. We're watching this case closely. If Barnes's family petitions the Supreme Court again, and they likely will, the court will have to decide whether to take up the case again. Will they? That's the big question. The Supreme Court doesn't usually like to micromanage lower courts. But when a lower court appears to blatantly ignore a clear, unanimous ruling, they might make an exception. If they do take it up again, this could become a landmark case about Supreme Court authority and what happens when lower courts refuse to follow orders. This is the case that won't die. And it shouldn't die because the questions it raises are too important to ignore. Stay informed. Pay attention. Because decisions like these affect every single one of us who might ever have an encounter with law enforcement. Your rights are only as strong as the court's willingness to protect them. And right now, we're seeing a real test of whether those protections mean anything at all. Claude is AI and can make mistakes. Please double-check responses.